Hello, everybody. This is our part 4 contract law 19th lecture series. I think that you have gone through all the previous lecture series of the contract law, that is from part 1 to part 3. Actually, I have spoken about regarding the contract law, and some of the basic idea that what do you mean by offer and acceptance, and the consideration also, and what are the various the concept and the definition which has been given in the Indian Contract Act 1872. Now, this is very important to understand that the offer and acceptance, that is the offer I am going to make, and the other party is going to accept my offer. I have little bit explained in my part 3 also, but I have mentioned one thing, like silence is no acceptance. Why silence is not acceptance? Because silence does not per se amounts to communication. In a landmark judgment which has been given in the case of State Bank of India versus the Rustam, the Kawarji, AIR 1955 Bombay 419, it has been stated by the court of law, Honorable Court of Law, that the mere silence cannot amount to any assent. That if, for example, if I am making any offer to the Y party or X party, Y or X, the Y or X cannot be, if they are silent, it does not mean that they have accepted. I have already expressed that the offer can be expressed or implied. Similarly, the silence to the acceptance cannot be taken into consideration. That it does not even amount to any representation on which any plea of estoppel may be found, unless there is a duty to make some statement, to do some act. Means you have to express yourself that you accepted that kind of offer, to act free. And the offerer, means the offer, for example, if I am making the offer, must be consent. So if any party like X or Y is accepting to act freely, then obviously then in that cases, that acceptance, mere silence is acceptance, otherwise it is not applicable at all. And when, like, acceptance must be unambiguous and definite, it means that unambiguous means it should not be having any kind of ambiguity in nature, uncertainty. It should be clear, it should be definite, it should be precise, it should be concise, and it should be related to the offer itself. Acceptance cannot be given before the communication offer. Why it is such that? Why it cannot be given as a before the communication to an offer? Naturally, if the offer is not made, then the acceptance to an offer cannot be taken into consideration. So acceptance happens only when there is an offer. For example, you don't know about the offer itself. For example, if I don't know what, if I'm planning to sell a property, and somebody knows, if I'm planning to sell a property by reading my mind, and he has given the acceptance, okay, I am going to purchase your property because you are selling your property, but I have not expressed anywhere, neither expressly or implied, they have not expressed anywhere that I am going to offer my property for sale. So it will not be taken into consideration. Now, there is also another very important concept called lawful consideration. In businesses, what happen in our day-to-day life also, I have already mentioned that what is consideration? It is quid pro quo. It means that something in return. So when you are entering into any kind of contract, there is always a consideration involved in it. According to section 2D of the Indian Contract Act 1872, consideration is defined when, at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstain from doing or promises to do, abstain from doing something, such act or abstinence or promise is called consideration of the promise. Consideration means something in return. It means that you are making something in return of the offer that has been made by the promisor to the promisee. For example, if I am selling a property, there should be something in return from the other party. That is, he or she has to pay the price of the property. And what are the essential of valid consideration? Means what are an agreement can only be supported by a lawful consideration on both the sides. Now, essentials of valid consideration must include that it must move at the desire of the promisor. It means if I am planning to sell my property, if I am entering into a kind of a contract, and if I am making any kind of an offer, then it must be at the desire of the promisor, because any act which is constituting consideration must have done at the desire of the promisor or the request of the promisor. For example, if A saves goods B from without paying, ask him to do so, A cannot demand any payment for his service. The consideration must be moved from the promisee or any other person. For example, under Indian law, it happens under Indian law. Under Indian law, the consideration may move from the promisee or any other person, that is even from a stranger also. So this means that as long as there is a consideration for the promise, it is immaterial who has furnished it. There should be a consideration, but it may move from the promisee or from even a stranger. But there should be a concept or material as a consideration. Consideration must be an act, abstinence or forbearance or a return promise. There should be a return promise in the case of a consideration. Consideration may be past, present or future. That is, past consideration is not consideration according to English law. However, it is a consideration as per the Indian law. Example of past consideration is A renders some service to B at the latter's desire. After a month, B promises to compensate A for service rendered to him earlier. So when any consideration is given simultaneously with the promise, it is said to be present. So past, present and future. There should be a past consideration, there may be a past consideration, there may be a present consideration, and there may be a future consideration also. The consideration must be real. That is, the consideration must be real, competent and having some value in the eye of law. That, for example, if A makes a promise to put a life to B's dead wife, if B pays him rupees 1000. So A's promise is physically impossible of the performance, hence there is no real consideration. There should be a proper reality. And then consideration must be something in which the promisor is not already bound to do. A promise is to do something when one already bounds to offer, or either by law or it is not a good consideration, since it adds nothing to the previous existing legal consideration. It means that it is not already bound to do so. So anything which is something which is not bound to do so, which is not consideration in the eye of law, then it is not taken into consideration. Consideration need not be adequate. Consideration need not be necessarily be equal to the value something given. So long as the consideration exists, the courts are not concerned as to adequacy, provided it is for the some value. There are some concept called unlawful consideration. That is, the consideration of the object of an agreement is lawful unless and until it is forbidden by law. It means, why it is forbidden by law? Because the object of the consideration of an agreement is doing an act or forbidden by law. The consideration should be allowed by the law. It should not be forbidden by the law. If it involves any injury to person or to property or another, you might be understanding, if there is any injury, then obviously it will not be taken into consideration as a part of the consideration. Then why it is such that? Because naturally, if someone is making an injury or default, then that kind of a consideration is not taken into account. Second is that if the court regards it as immoral, when an agreement has entered into between two parties and the consideration which involves here, it is immoral in nature, it is against the public policy, against the policy of the country, it is immoral in nature, it is not moral, then obviously it is not taken into consideration. If there are any kind of provisions in the agreement that it defeats the provision of any law, then also that consideration is unlawful consideration. It is fraudulent in nature, it is opposed to public policy, and agreements in restraint of legal proceedings. So one is the agreement restraining the enforcement of rights, and other deals with agreements curtailing the period of limitation. You cannot do so, because it should not be in restraint of any kind of legal proceedings. Trafficking in public offices and titles. What does that mean? That, for example, agreements of sale or transfer of any public office and title for procurement of public recognition, like example Padma Bhushan, Padma Vibhushan, Padma Shri, for monetary consideration unlawful. You cannot sell your title which belongs to, which has been offered, which is the conferred by the government or for the public use, for your public good. It has been the title has been conferred. Agreement restricting personal liberty, agreements which actually unduly restricts the personal liberty of parties to as void as being opposed by the public policy. Marriage brokerage agreement to procure marriages for the rewards are void under the ground that the marriage ought to proceed with free and voluntary decision of the parties. Agreements interfering the marital duties and the considerations may be taken in the form of money, goods and services, or promise to make any promise to forbear. So contract opposed to public policy can be repudiated by court of law even if that contract is beneficial for all the parties to the contract. What consideration and object are lawful and what not. In some of the cases like Newar Marble Industry was a Rajasthan state where it states that agreement which object or consideration was opposed to public policy are unlawful and void. What better, what more can be an admission of the fact that the consideration of the object as to abstention by the board from criminally prosecuting the petitioner company by the offence under section 39 of the Act, and that the board has converted into a crime, into a source of profit for the benefit of the to itself. So the consideration of the object is clearly opposed to the public policy, and hence the compounding agreement is unlawful and void under section 23 of the Indian Contract Act 1872. It is unenforceable against the petitioner company. So you have understood that what is the concept of consideration. Is very important to understand that which is unlawful consideration, which is lawful consideration, and if the consideration is opposed to public policy, it is in the nature of immoral, or it does not hold any ground in the eye of law, it defeats the provision of law, then obviously that consideration is not taken into consideration, and obviously if there is no consideration, there will be no agreement or contract between the parties. So thank you very much for joining. We will continue with the series of the contract law, and we will discuss each and every areas of how the agreement and the contractor came into a shade, whether in kind of an individual or businesses. Thank you very much for joining.